Bonani ninjani molweni afsheni tovela nda. Guys, today we are here with CVL procedure or civil procedure CIV3701, which you are writing on Friday. Good luck, guys, on the 28th. Without wasting time, guys, let's get into the business of the day. So most of you are going to write the MCQ. So it's very much important that we deal with the MCQs. So here we have the question here, which is question number 1, which deal with which is said indicate most accurate statements. So when you get into the examination, most of the examination will be showing that you must show or you must indicate the most accurate statement. So you must know that there's a statement that are accurate, but you must find the most accurate statement. So let's go. Number 1, when a claim for damages is instituted, the plaintiff must prove the guilty of the defendant. In a civil proceedings, the parties comprise the complainant and the defendant. In civil proceedings, judgment will be granted in favor of the plaintiff if the defense raised by the defendant is less probable than the claim proved by the plaintiff. As in the case of the Superior Court, a magistrate court has a discretion regarding its own procedure. So I will firstly show my answer. For me, I will choose number 3, that in a civil case, judgment is granted in favor of plaintiff if defense raises the defendant, if the defense that the plaintiff raised is more probable than the defendant, the one that defendant proved. So I'm going to also prove why I consider number 3 as a correct answer. Because number 1 says when a claim for damage is instituted, the plaintiff must prove the guilty of the defendant. Well, we have been doing ILW, and I know that you know that in a criminal case, the state usually wants to punish someone for a crime, and therefore if the accused is convicted or is found guilty, he or she will be pay a fine or go to prison. Therefore, you only found guilty when it comes to the criminal one. Therefore, since this one is to pay the damage. Then in a civil proceedings, the party comprise the complainant and the defendant. We have done in the ALW that the role players in a civil case is a plaintiff and the defendant, right? Plaintiff and the defendant. And if the case goes to the Supreme Court of Appeal, there will be a plaintiff, no, plaintiff and respondent. Then let's go back. Then let me prove number 4. Number 4 says, as in the case of Superior Court, Magistrate Court has a discretion regarding its own procedure. Although this is correct, however, this is not most accurate statement because this question, Superior Court has a discretion procedure. This procedure is being dealt by Section 173 of the Constitutional Court, which granted this court, the Supreme Court of Appeal, High Court, to have inherent power to regulate their own processes. However, this is different when it comes to the Magistrate Court. Why? Because the magistrate are creatures of the state statutes. When they exercise jurisdiction in the lower courts, they depend on the extent to which its enabling statute permits to exercise such jurisdiction. Right? They depend entirely on the Magistrate Court Act. It means that magistrate, when it comes to jurisdiction, it must depend entirely on the Magistrate Court Act of 1944, right? And it does not act outside of the scope of the Magistrate Act, right? So we have proof. Now we have to prove number 3. Number 3, let me prove it now. When I prove, you can see, in a civil proceedings, the burden of proof is on balance of probabilities. This means that the court must be satisfied that the version put forward by the plaintiff is more probable than than that put forward by the defendant, who they also called the respondent. Right? So we have done number one is tutorial. If you want to watch the full video, please support us by paying subscription fee of 15 Rand, which will enable you to watch all exclusive videos of CIV before exam on Friday, 28th of 2024. Or you can simply request unlimited class tutorial via Microsoft Teams for 800 Rand. We are determined to support you before Friday examination. Number 3. Most accurate statement. The only factor which determines whether proceedings may be instituted by way of application proceedings or by way of summons proceedings is whether material dispute of facts exists between the parties. The three sets of affidavit which are usually exchanged between the parties in application proceedings are the supporting affidavit, the answering affidavit, and the replication. The power of attorney usually seeks to redefine the extent of an attorney's mandate. Agent applications are used when the relief sought is preliminary step in the proceedings. So my answer here will be number 1. The only factor which determines whether proceeding may be instituted by way of application proceedings or by way of summons proceedings is whether material disputes or facts exist between the parties. So before I prove, I want to show you something, because this case mostly is dealing with applications. So there's a 3 sets of affidavit which we know, and then here is talking about the supporting affidavit, answering affidavit, and the replication. And then they said the power of attorney usually seeks to redefine and the extent of attorney mandate. Agent application is used to the relief sought is preliminary step in the proceedings. Then I want to teach you something so that you understand about the affidavit in the application proceedings before I finally move on to another question. I want to prove to you so that you only understand. So in order for you to understand, you must know that let me write in. You must know that there is a true form of application in court, right? Number 1, we have ex parte. Ex parte application. Number 2, we have the ordinary application. Never forget this. We have 2 applications. We have ex parte applications. We have ordinary applications. Then, ex parte, let's deal with ex parte application. Ex parte application as ex parte application is heard and granted by the court without a notice, right? For example, when you want to be admitted as an advocate, then you will send an application to the High Court with a supporting affidavit. Supporting affidavit is the affidavit that you'll be showing that you have gone through the pupillage in Johannesburg Bar, and you have gone for 1 year, you have met the requirements that are set out in the Legal Practice Act. Then now you want to be admitted as an advocate. So you will use ex parte application, right? And that application will be granted because without the notice, right? But this one is different from ordinary. Ordinary application is sent This one should be sent to other person. And then this is account. And this one as a notice. You must know that ordinary application is also called on notice, right? This one is sent to another person, and this one it must have a notice, and it must have a supporting affidavit. So this one is an ordinary application. You are sending to another person. Then you send it with a notice that on this day, when the court will take a decision, and the decision that will be taken will be final. Then you are sending an ordinary application. Then it must be sent with a supporting affidavit. If it is not opposed, then it's good. The court will hear because there is a notice. However, if you oppose, if the person you send to oppose, if somebody opposes the supporting affidavit, the supporting affidavit of ordinary application, what happened if someone opposed the supporting affidavit of ordinary application? It means that the three set of affidavit it means that the three sets of affidavit will take place. The first one is a supporting. Number two is answering. Number three is reply. Those are the three affidavits that must take place. There should be a supporting affidavit. Then the person you gave notice will answer the affidavit. Then you will reply to the affidavit. This is what happens between the expert application and the ordinary application. I have written down so that you don't forget even in the examination. Never forget, expert application has no notice, and mostly you are the one who send it, especially when you want to be admitted as an advocate. Then ordinary application, it has a notice which must be sent to another person so that she may know that there's an application proceedings in court. That person can choose not to oppose. If the person chose not to oppose, then the matter will end here. If you oppose, then there will be three sets of affidavits that will take place. Supporting affidavit, which the person will answer affidavit, and the one will reapply to the affidavit. I hope now you have understood this tutorial. If you want to watch the full video, please support us by paying subscription fee of 59 Rand, which will enable you to watch all exclusive videos of CIV before exam on Friday, 28th of 2024. Or you can simply request unlimited class tutorial via Microsoft Teams for 800 Rand. We are determined to support you before Friday examination. Understand the CIV. Let's talk about the action proceeding. Thabo wants to institute a divorce action against Mary. Thabo wants his neighbor, that's number one. Number two, Thabo wants his neighbor, Mr. John, to pay 5,000 that is owing. Thabo wants to know what type of summons he will use. Or let's increase here. Let's increase to 300,000. Yes, let's say 300. Let's say 300,000. Yes. So yeah, Thabo wants his neighbor, Mr. John, to pay 300,000 that is owing. So Thabo came to you to know what type of summon he will use and how he will proceed with this civil action. So you must know that we have something we called an action proceeding, right? Then action proceedings start by pleadings. During the action proceedings, there will be a pleadings. There's two types of pleading. One, we have a particular of a claim. Number two, we have a plea. In order for you to understand this particular of a claim or these pleadings, you must know that during the pleadings, Thabo, as a plaintiff, will send a summons which has a particular of a claim, giving details of the action and what he's claiming, right? This is Thabo. So he will either send a summons and particular of claim to Mary or Mr. John with giving details of the action and what he is claiming. That's Thabo, right? When Mary or John receive the summons and particular of a claim, as a defendant, they will send a notice of intention to defend, telling the plaintiff that they wish to defend. He or she wishes to defend the action. So this is happening during the time of pleadings. Then they are telling Thabo that they're sending Thabo a notice of intention to defend, telling Thabo that we will defend the matter, right? Then Mary or John, because they have sent a notice of intention to defend, they will have to write a plea. In the plea, they have to give details of their defense, meaning that they have to prove that there's a case on their side. For example, John will have to try to prove that on his defense, the money is not 300,000 or he has paid fully 300,000 Rand. Whereas in a divorce case, Mary will try to prove that certain kind of marriage, termination of marriage, it was not on his side, it was not on her side, or she is not happy about the way maintenance is being allocated, and they claim that Thabo wants during the on her particular of a claim. Therefore, Mary and John on their plea will give details of their defense. Right? Now I know you are understanding. Let me repeat. During the action proceedings, we start with the pleadings. Pleadings, we have a particular of claim and a plea. Particular of claim is the one that gives details of the action which is written by plaintiff, who is Thabo. Then plea is written by defendant, who is giving details of his defense. So it means Thabo as a plaintiff will send the summons and particular of a claim who is giving details of the action. Mary will have to defend such an action, will have to send a notice to the court of intention to defend the matter. Then they have to write something we call the plea, in which they give details of their defense, whether they are accepting some of the things that are contained in the particular of a claim, or they are opposing. They have to send what we call a plea. So now you have understood about the plea, the particular of a claim. Then if the plea by defendant contains new arguments, for example, John will say that I'm not owing 300,000, actually I'm owing 20,000, and be able to prove by new arguments. Then, or even Mary proved the new argument during during the divorce action, which are contained in the particular of a claim, showing that she has a proof and she has a new argument. Then Thabo as a plaintiff will have to write another pleadings called replication. Now, you understood. I hope that you understood everything about the pleadings during the action proceedings. Replication is only written when there's a new argument from the defendant's plea. Then the plaintiff will have to write a new argument in which she agrees with new arguments or opposes the new arguments. There are other pleadings that are written, such as a rejoinder, surrender, or all other pleadings. Then after the pleadings have been, then the pleadings close. The pleadings will do what? Will close. So these are the steps that takes place during the pleadings. Now, let's go and understand. Since we have a question here which we are waiting, we told about what happened during the pleadings. However, we have not mentioned the type of summons which is applicable to the Mary during the divorce action and during the payment of 300,000 from Mr. John. We need to know the type of summons which Thabo will use. Since we are now aware of a particular of a claim and we now are aware of a plea, it's very much important now to know the summons that Thabo will use. Therefore, you must be aware that there are three kinds of summons, right? We have a combined summon, we have a simple summon, and we have a provincial sentence summon. However, we will speak about these first two summons, the combined and simple summons. Let's start with a simple summon. Simple summon. This one, claim liquidated amount. Remember, when there is exactly amount fixed or certain amount, you choose a simple sum. You must know that the pleading document is declaration This means that where since here we said that, let me show you. Since here we said that Tabo will have to send a summon with a particular claim. It means that in the case of a simple summon, he will not use particular claim, but he will use what we call a declaration. Declaration. You must not forget. He will use what we call a declaration. However, because it's a simple summon, he will use, instead of particular claims, he will use a declaration. Declaration is the same as particular claim. It gives details to action and what the person is claiming. However, it's just that in the simple summon, they call it a declaration, whereas in the combined summon, they call it particular of a claim. You must never forget that. Right? So, now let's come to combined summon. This one is used for any claim. However, if you are claiming a liquidated amount or a debt amount, you have to strictly use simple summons. Do not forget, combined summon is used for any claim. However, if you want to claim a liquidated debt or a debt amount, you have to be using a simple summon. Combined summon can be used to claim damage because the court has to figure out how much. Combined summon is used when there is a dispute. Dispute of amount claimed. So if you go to the dealer and take a car, you have to be paying 10,000 per month. Then maybe you have taken the car that was worth 300,000. You're able to pay 200,000. Then you spend 3 months without paying the other amount. Then this will be used as simple summons where your dealer will just go and say that the person is owing me 100,000 rent. Therefore, you will put some percentage because you couldn't pay, then they calculate, then it's fixed. Then there is no dispute of amount. The only thing that you just need to prove is that the person was not paying. And you need to provide why you were not paying, or you were paying, but you come with a proof that you paid, or they come with a proof that you're not paying. That's all. There's no dispute about the amount claimed. However, when there's a damage to the car, someone can say that the amount should be 300,000, whereas another can say that there was a negligence in the part of the driver, so the damage should be 200,000. There is a dispute of amount claimed. Therefore, the court has to be the one to determine the relief. That's why we call this a combined summon. Even when you go to the question, when you see the question on the examination, in the multiple choice question, this summary that I'm giving you, it will really help you to understand and answer the question very fast. Right? Combined summon must contain this means that the pleading document that must be used on the combined summon is a particular of a claim, right? Particular of a claim. You must never forget. On the simple summon, we say that the pleading document is declaration, whereas on the combined summon, we say the pleading document is particular of a claim. Now, because the divorce, the amount is disputed. It means that Tabo will use a combined summon to institute a divorce action. I hope now it's very understandable, and now you can able to understand, because there's a dispute of amount claimed, then Tabo will have. When you get the MCQ question, if they're asking what type of summons they will have to use, you must never forget that if the question is dealing with the damages or any amount that will be determined by court, then you must know that a combined summon will be the one to be used. I hope now you understood about the types of summons, and when you get a question on the MCQs, you will be able to answer these all questions. This is a tutorial. If you want to watch the full video, please support us by paying subscription fee of 15 Rand, which will enable you to watch all exclusive videos of CIV before exam on Friday, 28th of 2024. Or you can simply request unlimited class tutorial via Microsoft Teams for 800 Rand. We are determined to support you before Friday examination.